Welcome to Notable Approvals. I am attorney Amanda Shaffer. Today we have a great naturalization case to talk about. And we're starting to talk about naturalization now because in 2 Thursdays, and I'll get the date out later, we will be having a Q&A discussion on naturalization. So make sure to like us and follow us so that you don't miss it. Today's case is about a client who is a native of Venezuela and now a U.S. citizen. He came to us right after his naturalization interview. It didn't go as planned because at the interview, he learned that he was still married to his ex-wife, and now he's married to a second wife, which is illegal if you intentionally and knowingly do it. It's called bigamy. But he said, well, look, I honestly thought I was divorced. So this all came up because whenever you go to a naturalization interview, even if your green card's not based on marriage, they want to see evidence of your marital status. So if you got married, got divorced, you bring those documents. So they said, okay, let me see your divorce, because it had on there he was remarried. So he hands them the paper he has, and the officer looks at it and says, this isn't a divorce. This isn't a final divorce decree. Where's your divorce? He's like, I'm divorced. Like, even my ex-wife I know got remarried. So he was given a request for evidence at the end of the interview to bring the divorce. And he called us like right after that interview and came in, and we said, okay, bring all the documents that you have from the divorce, because his ex-wife was the one who had filed it. So let me mute that. How do we mute this thing? Okay, there we go. So we looked over everything, and apparently there was a stipulation for dismissal that he signed. And when we looked up the index number in the computer, we couldn't find it, the divorce. That usually it says like uncontested, matrimonial, granted. And the stipulation of dismissal was to stop the divorce. So we said to him, this shows that the divorce was never finished, that you agreed to stop pursuing the divorce. And he thought he was signing an affidavit of defendant. At the time, he did not speak a lot of English. And he legitimately thought that he was divorced. So we only have like 30 days to respond to the request for evidence. And in New York, at least, it takes a lot longer than that to get a real divorce. But that didn't matter because we still had to show that, look, he did not intentionally and knowingly marry another woman while still married. So we replied to the RFE. We didn't have any documents except, his affidavit explaining, look, I didn't know. My wife did the divorce. I was supposed to just sign a piece of paper and it was done. That's what I did. I thought it was done. And it was years ago, too. It was like 10 years before his naturalization interview. So no surprise, they denied it. And you get, whenever any application with immigration is denied, there's always a question of, do I appeal or do I refile? And if you've watched other notable approvals that we've had, in a lot of cases, the correct answer is to refile. But in this case, hi Ragnar, I'm sorry. Hi Ragnar, how you doing? Thanks for joining us. So in this case, we're like, look, you have to have intentionally and knowingly, and it said that in the denial, that he intentionally and knowingly married another. And you didn't do that, so this is wrong. And we think you can overcome the grounds for denial. Plus, he still wanted to get divorced from his ex-wife. So we immediately filed for divorce. We were able to get in touch with her. She agreed to do the divorce. And we wrote a detailed affidavit for him explaining exactly why he believed that he was divorced and that he didn't lie on his naturalization application. He didn't lie in his interview. And with the naturalization application, it's not called an appeal or a motion to reopen or reconsider. It's called a request for like a rehearing, or it's the form N336. So we filed that, and we filed the affidavit, we filed the judgment of divorce, and it was granted. And our client also had his divorce granted too. We were able to get the divorce granted before we had to respond because we replied to the RFE. It took them months to get back to us. But once we had the denial, we only had 33 days to reply to that. Otherwise, his naturalization would have been denied, and he could have been looking at removal proceedings. It was denied based on a good moral character issue, not based on like a criminal offense, but it is illegal in the state of New York to marry another person while you're still married. So yeah, it was a very interesting case. We have one question. Is it possible to obtain a visa for the fiance of a person with permanent residence. Well, we're not talking about that right now, Ragnar, but no, it is not. You need to be a U.S. citizen to file a fiancé visa or a K-1 visa. So yeah, the thing I wanted to say about the marriage, though, with this client, or the divorce, was that this is not the first client who's came in to our office thinking he was divorced, or she was divorced but was not. Unfortunately, it happens, and the important thing that you do is you fix whatever the case is, whether you're going to have to get remarried to your current spouse, but first get actually divorced. We've seen it a couple of times, and immigration is very strict about that. So that is all today for notable approvals. As I said, I'll be posting an announcement about our next live Q&A discussion. It will be about naturalization. So like us and follow us so you don't miss any more. If you have any questions, Ragnar or anybody else, please feel free to contact us. Contact information is at the bottom of your screen. We hope to see you tomorrow for another notable approval. Have a great day.